My name is Ifeoma Odunlami, for those who do not know me, and I want to introduce myself. My office is in New Jersey, but we serve clients in all 50 states. We're an immigration law firm, and that's all we do. Immigration, we do family-based, and we do humanitarian. The standard for a waiver is proving extreme hardship to a U.S. citizen, spouse, or parent. That's a typical waiver. Now, if you're in a situation where you're in deportation proceedings and you're seeking cancellation of removal, you can also seek a waiver with your child as a qualifying relative. But in most cases, right, except certain cases, your child cannot be a qualifying relative. So let me explain that. I'll break this down. For a lot of people who came through the border, so you're coming through the border, you were not inspected, you were not admitted, and you come in, and then you've been living in the United States all these years, you have American children, and one of them turns 21 and they can file for you. The I-130 will be approved, but because you came in through the border, you were not inspected, you were not admitted, you're gonna need a waiver. And unfortunately, in this situation, your child cannot be a qualifying relative for a waiver. So that application leaves you nowhere, at least you're stranded. You can't get a green card. Now, let's twist this a little and say that when you came in through the border, you weren't inspected, you weren't admitted, but you came in and you fell in love with a US citizen, right? Or a green card holder, and then they filed a petition for you, you needed to file a waiver because of the manner of your entry. Now, you can file a waiver. You would have to file an I-601A waiver to waive the manner of your entry. And so you would have to file the waiver, have the waiver approved here before you leave. And when the waiver is approved here in the United States, you can take the waiver approval and you have to go back to your country and go before the embassy and come back through consular processing. Now, if you have committed a crime, which this is really important, that's why it's so important to be honest with your lawyers. If you committed any kind of crime, right, remember there are different types of waivers. So if you're getting a waiver for unlawful presence, that's not a waiver for a crime. That's not a waiver for a misrepresentation. So if you have a waiver for unlawful presence and you take that waiver and you leave, but you didn't tell your lawyer that you had been convicted of a crime or you had committed a crime involving moral turpitude or anything like that, and then you go out and the officer at the embassy interviews you and they realize that you have committed some kind of other crime that made you inadmissible, you're not going to be able to come back to the United States without filing another waiver to forgive that particular crime or immigration violation because you didn't indicate at the time that was committed a crime. So it's important that your lawyer knows if you're leaving the country, especially on a waiver, a 601A waiver, that they know if you've been convicted of any crime because you want to make sure that you have the right waiver that allows you to come back.